This video is to help deepen our knowledge of what is common law, and we're going to start with the black belt barrister who is explaining to his audience what it exactly is common law.
What exactly is common law? You'll have heard the term used with increasing frequency over the last few years,
So before we even get there, we got him addressing the audience under the title of a black belt barrister, and I think that maybe be best for us before we get into his interpretation of what common law is that we first maybe get a better understanding of what is a barrister. Bringing to your attention, and something I just pulled up, you Google, barristers into the court, you'll get a lot of different history about them. And this is through Britannica, I guess, association with the British Legal Association, that we can skip off the first part and go into the second paragraph in order to get some perspective of what these inns of the court are so we could understand what a barrister is. It states here that the inns of the court are voluntary societies, unchartered and unincorporated, hence their early history is obscure. Since their inception in the Middle Ages, however, they have been devoted to the technical study of English law rather than Roman law, which was taught in the universities. So what they're saying was taught in universities? Roman law. And we go on to this, by the mid 13th century, when the common law had become extensive and intricate, there arose a class of men, literate but lay, who created and dominated the legal profession and set up the inns of the court as an answer to the problems of legal education. Manuals and books were produced in French rather than Latin. The students listened to the arguments in court and discussed law among themselves. So as we can see here, you can discern that we're talking about two different types of law. There's so much information in this one paragraph that it can easily go unnoticed. We are speaking about inns of the court, but we're speaking the inns of the court of English law that dealt through the first French language. In fact, after the conquest of AD 1066 and William the Conqueror, William the Purchaser, was obviously of French descent, and therefore all of his courts therefrom became listened to or heard through the language of French. Latin, on the other hand, is a Roman language, or the language that the Romans used, and as such, as it went into that, the Roman law was taught in the universities. Now, if we went to Cambridge and Oxford, who created those two universities? Well, the universities are of the Roman law or the Roman church descent. They are of the clergy. Thereby, they don't speak to the English law predominantly. They have no interest in that. They're speaking to the matters that they have an interest into, which is the equitable rights to the use of land. Since they are a perpetuity instrument, they have no life, as we have through the laws of nature, and they're created through the minds of men. So they only have the right to discuss those matters, not of the common law of the English law, but the matters that they create through the equitable use and the rights to land. We scroll down to the second part. In addition to those who practiced in the courts, there was also a large demand for stewards and legal advisors to landowners to conduct general business and keep manorial courts. These men needed the rudiments but not the refinements of common law. It just tells you right there, these new stewards and legal advisors, manorial courts, meaning those courts belonging under each lord and baron, tenants in chief and such, had their own courts in order to deal with their own issues within their own territories. And they, obviously, those who had worked the land, who didn't have the status, therefore the right to a tenure directly under the king, had to have their own means in which to have redresses against either A, against themselves, among themselves within the manorial jurisdiction, the territorial jurisdiction, or against the Lord. Where was their redress if they couldn't go to the king? They had, why, a lot of cases, manorial courts, 1/3 of the land was set up not regulated by the common law, but by equitable use through the church. And then the church became the vehicle in which then would be part of the court system so as to make sure that the people are heard. Okay? Now, as we go further down here and read down, such too was the case with a large class of attorneys and a growing class of bookkeepers and correspondence clerks. They gained most of their knowledge through the Inn of Chancery. Okay? So we should just highlight that, just for the fact that, just to keep it in our mind, that we are now speaking to a different matter than what was created through the Inns of the Court, an institution for training in the framing of writs and other legal documents used in the courts of chancery. So now we've discerned that we have two different types of subject matter. One addressed to the Inns of the Court, and the other one the Inns of Chancery. As we read on, the 14th century, many of the household clerks, clergy with at least minor orders, and as you probably, many of you know, that if you became a monk, you were dead in law. You could not be seen in law because now you are serving the church, which is obviously a different type of law. As we go on, of the Chancellor's office formed inns and appear to have taken students for training. By the end of the century, these inns were in danger of being submerged by a flood of attorneys-to-be. Wow, boy, are we not experiencing a flood of lawyers and students who use an Inn of Chancery as a preparation for entering an Inn of the Court. Eventually, each Inn of the Court secured control of one or more Inns of Chancery and supervised its affairs, appointed readers to teach in it, and later often bought its premises, becoming the landlord. So, who's becoming the landlord over the court of the courts of chancery? Obviously, the Inns of the Court. And who are the Inns of the Court? The law. And that's where the barristers were. In fact, you will find, if you do some research, that it was the Roman church lawyers, the clergy, that called the barristers, who were the Inns of the Court, heretics, because they dealt with their interest in a right to land. They weren't dealing directly with people. Where the civil law, if you know anything between Roman and English law has always put the rights into the land, to which then people came in under that right, and then that created the obligation. Whereas the Roman Church removed man, but gave the rights to persons. And that's the civil law. Civil law puts the right into the person, or that's the power of equity, puts the right into the person, whereas common law, the English law, puts the right into the land. Moving on down the page, because the law was highly technical, proficiency could be acquired only by following the demanding studies of the inns. So now we've got a couple of different, we already know the two different types that there are. In practice, the inns thus had a monopoly over legal education. In the 15th and 16th centuries, however, many students joined the inns for the purpose of getting a general education rather than legal training. By the end of the 16th century, the Inns of the Court had begun to exclude attorneys and solicitors, and there's your lawyers of today, people, and refused to call them to the bar, with the result that attorneys especially fell back on the Inns of Chancery and finally came to form a profession distinct from that of barristers. So, when you call yourself a black belt barrister, are you technically a real barrister? I would say no, and the reason why, we're going to get into that point as we further on in his video. Instead of pause this, what we just see, we can scroll down and get to the final point. In 1974, the Inns created an administrative body, the Senate of the Inns of the Court, and the Bar, which oversees such matters as finance, legal reform, and educational standards. This point is extremely important because it really defines what we are speaking about and making sure we're separating subject matters of what is actually happening. We have already engaged in the distinct division of what the Inns of the Court dealt with, which was the common law investigated through the Inns of the Court, and to which then those of lawyers under universities, trained in universities, discuss where that they were bound to matters of Inns of Chancery. Now, so you can't combine the two. They are completely two different subject matters. And that's another reason why the monarchy was instilled after they destroyed all the ritual pieces, after Cromwell came in, and there was no monarchy for a stint. And the reason why, logically, because law is reason, the monarchy is the one to give power to the government in the first place to administrate over the equitable interests which come through the Roman Church. Okay, that equitable use to land. So that's all that government has a right to. So, in order for them to follow a syllogistic reasoning, for instance, we can obviously come from the very distinctive fact that man created titles, therefore titles can't be greater than man. Titles, like the monarchy, created government, therefore government cannot be greater than its creator, the monarchy. Government creates citizens, therefore the citizens cannot be greater than that of government. So, syllogistically, we have to realize that where the law, the Inns of the Court, and the barristers at that time could not be lesser than those matters of equity, because equity didn't have any rights in the common laws. I've already discussed, and I'm repeating myself here, but they had a different right over an interest in land through the person having rights to that interest, to which then they regulated and created courts in order to govern that right. So, so now we get down to the bottom of this. We see that the 1974, the Inns created an administrative body, the Senate of the Inns of the Court, and the Bar, which oversees such matters as finance, legal reform, and educational standards. To which bring this whole part home is that this is a new agreement. Very important to see here. Do you see what just happened? This is an agreement between the Senate, created the Senate of the Inns of the Court and the Bar, together merged but not merged. Okay, this is very important. Not merged based on the interest, the subject matter they hold, because they couldn't ever merge. They are two separate, distinct interests. What merged together was and come to an agreement. Now that agreement, okay, do you see where I'm going with this? That agreement becomes the foundations for courts and legislation and so forth to now make rules under. And here we are. We've evolved to this point. We are under that new agreement. If you're a citizen, you're under that agreement. You're not dealing directly with the High Courts of Chancery. And you can see, if you went to the Settled Estates Act, 1856, you'll see that a grant was given to the High Courts of Chancery to administrate over the sales and leases of settled states under the settlement. Well, what's under the settlement? Well, that would be the Inns of the Court. That's what they deal with, okay, predominantly. So, again, we've got two different subject matters. Same as like a landlord having ownership and the tenant having possession. They don't, possessionary, the one of the who is a tenant cannot ever control or overreach the power of the original legal document. They're not even in the same category. But where they come together is a new agreement, and then that agreement then becomes the administrative vehicle in which to discern problems or issues arising between the two parties. So let's turn back to the black belt barrister, and I think he does a phenomenal job. I've listened to a couple of his videos before, and he is speaking to what? When he's speaking to common law here, and he's discussing common law, what is he speaking to? Now that you understand, is he truly a barrister, or is he actually a lawyer under the new agreement, which then deals with the common law subject to an equitable use to land, therefore not the true common law that we've learned that was administered through the Inns of the Court and dealt directly with the barons and lords who were immediately under the king through their own allegiance.
Written. The UK has a parliamentary system of governance, with the Westminster Parliament being the supreme lawmaking body.
All right. So he's telling you right there, Westminster Parliament being the supreme law-making body. Now that is the common law. It's a territorial law that is he's speaking to which his duties and powers and his licensing then has a right to debate under. He has zero right to be discussing any matters in the English common law through that were administered, originally, and I'm sure still are, through the Inns of the Court. That would be matters that the Lords Temporal, the Lords would speak through, whereby I think the Lords Spiritual will still have their own courts, essentially, because they deal in canon law. We're dealing with Lords Temporal, would be dealing with the common law that is evolved from the feudal land tenure system through the laws of inheritance, and those still continue. The only thing that's been removed, we have we can bring our attention to the abolition of Tenures Act 1660 and thinking, okay, there's no more tenures. Well, that's kind of a wishy, that's not really true. The tenures that were no longer enforced were the ones that were resulting from the fee, which was the direct agreement to provide a service for the right of that tenure. What still continued under the common law was the entail and the life. Are those interests still in play? Absolutely. Just because the Law of Property Act 1925 only went down to limited or condensed the two interest in land to be a fee simple absolute or a leasehold, doesn't mean that those interests that were held before were eliminated, because we've already learned through a syllogistic approach, it got its power from the original tenure system, the original common law, in order to then have a right or look to a right to create the fee simple absolute and the leasehold, which eliminates the idea of the entail. That was the real point where the law of property does not discuss the entail anymore, which is under the laws of inheritance, which is a common law right. All right, we return. Sorry for that little glitch there. I have two mouses, and sometimes I grab the wrong one, and obviously I push the wrong button. All right, let's further investigate what the black belt barrister is speaking to.
Through a series of checks and balances, the judiciary will ensure the residual freedoms of individuals, look at any act taken by the state.
And there we are. He said individuals, but individuals within the state. There are individuals before the state, of course, and there's individuals before the crown, of course, okay, or before the monarchy. So when he's speaking, he's always going to speak under that new agreement, which then under that agreement, everyone is an individual within the collective group, and then that group excites a new legal personage. So it's one entire agreement, like Canada or US or England. That's one group that then the government administrates over that right to then who now become the people become obligated by the very actions to then agree to be administrated by the government itself through what it has to offer. And as we've already learned, the government doesn't own land. It has a second right of use to land because the original right is held in the monarchy, to which then created a legal state for which government to then have a right to. Then they've created their laws based on an equitable interest to that in conjunction with that legal estate, to whereby then it created another level, which is the third level of use, to which citizens have to have a right to use what government is offering under their rights, under their grant. So when he's speaking to this, he just says right there, each individual can take action or have a right to use the law against actions against the state. Well, if you are the people before the government, does that matter to you? Does any lawyer matter to you? Does anything, the banking community, have a right? Do they have a right over you? Would they ever bring you into court? And there's jurisdiction, because jurisdiction, as we've learned, is status and subject matter. That's what creates jurisdiction. So no police, no agency of the government, no corporation, none of the banking community would have any means in which to intercourse with you, because because you can't be seen in their jurisdiction, because you're not there. You have actually removed yourself from that jurisdiction under government and executing your legal estate properly, either as a beneficiary or as you're vesting it as a settler. That's your options. So no one's doing anything, even when people go against and fight, and that's what's happening. You're going in the system to which a guy like Black Belt Barrister is licensed to protect, and the court system is protect, to which they're there to protect the legal personas created through the government, to then go after anything that these guys say, except it's these guys who created the rules in order for you to then fight against. So it's like you're going into, you're fighting against the mafia, all right? And you're going into their house and saying you have no power over me, but you're giving them the authority to make that decision in the first place in their own house. You're just creating a circle jerk, and that's what all of this free men sovereign movement I have learned. Like I said, I went through it. Is what the predominant issue is. They don't know what law is. They don't know what equity is. They don't know the difference between the different courts, and they go with the lowest court to fight within the lowest court among their rules, which has nothing. The government has nothing to do with that individual. If that individual became knowledgeable and no more ignorant of the law and vested their legal estate, because the government has a burden based on the grant that it was given. No one's doing anything to you. You're doing it to yourself, as I continue to say, because you're the one who's making the agreement to make purchases and be regulated. As a citizen, you're using the government-owned birth certificate. It's not even yours. I proved that in court one time. I just asked the judge, the master, I said, so when you're asking for the name David Higgs, are you looking for the legal title owner of that name? Are you looking for the beneficial title owner, or the legal title or the equitable or beneficial title of that name? And after a couple of times of asking that same question, not getting out the question, they answered the legal title. Well, I don't have the legal title. I can't. The government owns it. So with that note, I hope that I helped clarify that. Stop, creating, I don't know, do what you want, but if you're going to start dissecting this guy's work, would it not be better to understand what law is and what he's talking to and the agreements they're talking to and what his position is before you start fighting against the juggernaut that you are agreeing to by the very obligations that you're setting in motion through your purchases of legal estates and property and citizenship, using their documents in order to just daily govern your life. I mean, come on, common sense. And with that, hope you enjoyed the video. Hey, Like, subscribe, share. Come on, let's get that. Everybody's going, hey, we just need to get into one, let's all get together. You can't get together. It's impossible because everyone has a different idea of what they think law is, and they got that idea because they don't know what law is. They interpret how they think what law is, and then we all get in trouble. So if you want to get all together, the only way is you have to become an individual first, because only individual is true, not under a group, because a group is a first of fiction, has to become an individual, and then use the law in order to settle their interest, the legal estate. Are you picking up what I'm putting down? I don't have a mic to drop. Here.